Button. So let's wait for the stream to fire up all across the internet, and then we're going to go ahead and get started. We've got a lot to get into, and as you know, on Tuesdays, we got to go quickly, don't we? But it looks like we're alive and well, so let's kick it into high gear. Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group in the always beautiful and sunny Scottsdale, Arizona, where my team and I, over the course of many years, have represented thousands of good people facing criminal charges. And throughout our time in practice, we have seen a lot of problems with our justice system. I'm talking about misconduct involving the police. We have prosecutors behaving poorly. We have judges not particularly interested in a little thing called justice. And it all starts with the politicians, the people at the top, the ones who write the rules and pass the laws that they expect you and me to follow, but sometimes have a little bit of difficulty doing so themselves. That's why we started this show called Watching the Watchers, so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency back down upon our very system with the hope of finding justice. And we're grateful that you are here and with us today because we've got a lot to get into. Oh boy. And we have some breaking news, actually. Derek Chauvin, his attorneys filed a new motion like 10 minutes ago. So I haven't even read through it yet, but we do have it clipped. We've got a lot of Derek Chauvin stuff to talk about. There is the juror that we've already spoken about, Brandon Mitchell. Somebody went and sort of dug through his social media posts and found some imagery of this guy wearing a BLM hat and wearing a BLM shirt. Kind of doesn't bode well for that concept of impartiality that jurors are supposed to embody when they're going through a trial. So we've got a lot to break through on that. Then we're going to change gears a little bit. We're going to talk about more critical race theory. We got into this a little bit yesterday, going through the article from James Lindsay that gave us that crash course on what CRT is and why it's so pernicious. There is a lawsuit that's taking place. An attorney by the name of David Pivtorak is filed a lawsuit actually today against California and their entire government, basically saying that this CRT stuff is highly discriminatory and unconstitutional. And so we're going to go through that because we have some of the Derek Chauvin stuff. That segment might be a little bit more condensed, but we are going to go through the lawsuit because it's very interesting. And it will be, I'm very curious to see how some of these lawsuits will unfold because we're talking about some pretty important constitutional issues here, in particular about, equality and the inability to deny certain classes certain benefits and certain rights. We're talking about discrimination here. We've got a lot of laws about that, and so it sounds like what California is doing is sort of reversing discrimination. But we're going to go through the lawsuit. We've got a lot to get through there. CRT stuff is everywhere, very pernicious these days. And then lastly, we're going to talk about the CIA and the FBI, because yesterday CIA headquarters was attacked. You may not have even heard this, but there was a gunman yet to be identified who was killed right outside CIA headquarters yesterday. And so you're going, what the heck is this? Is this Matt Damon coming out of the woodwork doing a little Jason Bourne action, or what's going on here? Then we know that House representatives are sort of really putting pressure on the FBI because of some of the FISA violations. There was a new opinion that came out from those declassified opinion that came out of the FISA courts that said that, hey, there's kind of FISA violations all over the place. If you're not familiar with this, we're talking about the Foreign Intelligence Surveillance Act and sort of spying on American citizens, even though this was set up for foreign surveillance. That's why it's called foreign intelligence. Many Americans are getting caught up in this. Talked a lot about that last year when we were going through some of the Michael Flynn saga. And so we're going to talk about that because Representative Jim Jordan and Andy Biggs here from Arizona are sent a letter over to Director Wray from the FBI saying, hey, well, we're not happy with what you've got going on here and we want answers. So we're going to go through that letter. We've got a lot to get to. Tuesdays are a little bit shorter than normal, so I just wanted to flag that for you. But if you want to be a part of the show, you can do so. Go on over to our Locals platform. It's at watchingthewatchers.locals.com. So just type that into a web browser. Head on over there. You can support the show, and I'm really excited about what we've sort of got in store for Locals, because I think there's some good ideas being kicked around over there about what we can do. But the point is that's a separate conversation. If you want to participate in this show, you can do it there. Watchingthewatchers.locals.com. There is a live chat over there. So ask a question, leave a comment, lob a criticism our direction. Ms. Faith is going to clip those. We're going to put those in the slide. So we're going to answer questions in between each different segment. And as always, we really appreciate your support. As you know, YouTube demonetized us. And so that's a bummer. If you want to support the show, Locals is really the place to do it. Awesome platform, a lot of good people there. So thank you for that. And we're going to get into the news, of course. There is a new photograph of Derek Chauvin, juror number 52. Remember, this trial just wrapped up, and juror number 52, a guy by the name of Brandon Mitchell, went out in front of the media and started giving interviews. And when we covered this last week, we were a little bit curious about what he was saying, because if you recall, a lot of the language that he was using was sort of indicating that he kind of wanted to be on this jury panel. Use some language like, we have to get in there. We have to get on these panels so that we can effectuate an outcome. And he did that, right? He was successful. It sort of reminded me of kind of, elbowing your way into the front of the line or into the front of the room to make sure that you are seated there because you feel like you have an obligation to vote for a particular outcome. That's what his language sounded like. Sounded like, well, this wasn't really a fair and impartial juror, even though during his voir dire, when he was questioned prior to the trial starting, when we were in jury selection, he gave a bunch of answers sort of implying that he had not made his mind up on this thing. Well, now we know he's got photographs of him in BLM shirts and shirts that say, "Take your knee off of my neck." And you're going, how can somebody like that, who is photographed in clothes like that with this particular disposition, how can they truly really be fair and impartial? And this guy got onto the jury and actually was a deciding vote on the conviction. So this is everybody scratching their eyes, scratching their head going, hey, what? This is not right. This is not, a fair and impartial juror here. So we got to break this down. Let's go into it. We're going to start over here from the Washington Post, which is surprising. They're even the Washington Post is going, oh, this doesn't look too good. So it says here, photo of the Chauvin juror wearing BLM t-shirt at the march raises questions of impartiality, experts say. So a photo has surfaced in recent days of a juror in the murder trial of Derek Chauvin. It's prompted questions. Photo shared by several news sites shows Brandon Mitchell, 31-year-old high school basketball coach in Minneapolis, standing next to two relatives wearing a black t-shirt with a picture of Martin Luther King with the words, "Get your knee off our necks," as well as a black baseball cap with the letters BLM for Black Lives Matter. On Monday, Mitchell told the Star Tribune that the photo was posted on social media by his uncle in D.C. last August, during the commemoration of MLK's "I Have a Dream" speech from 1963. He defended his attendance, saying it was not a march for George Floyd, according to the Star Tribune. All right, and so I am all for people joining causes. I'm all for people participating in the American experiment and voicing their opinions and their dissents and on and on and on. But that's a different question than whether you are a fair and impartial trial when you're sitting in a court of law having sworn an oath that you can be fair and impartial and that you're going to answer questions truthfully, because it sounds like maybe that is not the case here. Yes, we know it was a commemorative speech for MLK. Great. That's awesome. You can go, everybody go and support that. That's a good thing that we're celebrating MLK. But what he was doing was actively advocating for one particular political persuasion, in this case, BLM. How do we know that? Because the hat said BLM on it. And it also, he had a shirt. I think we have the image of it. So it's not a good look and pretty obviously not impartial. All right, The Hill has some more information for us. Chauvin juror, on attending the protest, he said, "It was a good opportunity to be a part of something." Juror who voted to convict Derek Chauvin is defending his decision to attend a social justice demonstration last year. Brandon Mitchell told the Associated Press, "I'd never been to D.C." Saying that he went to commemorate MLK, says the opportunity to go to D.C., the opportunity to be around thousands and thousands of black people, I just thought it was a good opportunity to be a part of something. During the jury selection process, all jurors were asked two questions as part of a jury selection questionnaire. Number one, did you or someone close to you participate in any of the demonstrations or marches against police brutality that took place in Minneapolis after George Floyd's death, the first asked. Okay? Other than what you have already described above, have you or anyone close to you participated in protests about police use of force or police brutality? Mitchell reportedly answered no to both questions. Right, and if you're somebody who says, okay, well, that's legally accurate, right? He wasn't at a protest, protesting or marching against police brutality. He wasn't for that at all. He was there to honor MLK. And so he answered that question truthfully, because it didn't ask, have you been a part of any civil rights demonstrations? It says, did you or someone close to you participate in any demonstrations or marches against police brutality that took place in Minneapolis after George Floyd's death? No, he didn't. Went to D.C. He was not even in Minneapolis. He was in Washington, D.C. for something that was not against police brutality. It was honoring MLK, right? That's one way to interpret it. The other way to interpret it is this guy knew what the question was getting at, and he explicitly lied. He was doing the lawyerly thing and said, no, I wasn't in D.C. Nope. Or I wasn't in Minneapolis. I was in D.C. No, I wasn't marching against police brutality. I was marching for civil rights. Okay. Right? And that's what lawyers do all the time. It's a legally permissible thing to do. Mitchell separately told Chauvin's attorney during the selection process that he had a very favorable opinion of BLM and that some police officers are great guys. He insisted he could be impartial during the trial. It was directly related to MLK's March on Washington from the 60s. The date of the March on Washington is the date. It was literally called the anniversary of the March on Washington. Mitchell told the Star Tribune in reference to the demonstration he attended last year. So, right, technically, I think he answered the questions correctly. Other than what you already described, have you participated in protest about police use of force or police brutality? So if he characterizes the MLK march, the March on Washington, as something that does not fit within that category, something that is not focused on police use of force or police brutality, then you could say, well, he was answering that question appropriately because it was responsive to the question. The question didn't ask about DC or civil rights. It asked about use of force and police brutality. All right. Well, maybe, yes, but the shirt that you're wearing certainly looks like it's got, get the knee off of my neck. It looks like that you are, in fact, protesting police brutality. So let me take a quick look here. I want to make sure that we have the pictures coming up. So we're going to go through a couple more articles, and then we're going to get to the photographs themselves. The Chauvin juror who attended the pretrial rally may jeopardize the guilty verdict. This was posted on Monday, May 3rd. By Valerie Richardson, said the march was held to commemorate the anniversary of MLK's I Have a Dream speech, but the National Action Network billed it as the Commitment March. Get your knee off our necks. Several members of the Floyd family spoke. Okay, so now we're seeing what this looks like, right? This juror, Brandon Mitchell, may not have, when he was answering the juror questionnaires, may not have considered that to be a march against police brutality because he was characterizing it as an MLK march. But then you look into it a little bit further. It was the Commitment March. Get your knee off our necks. Okay, that sounds like a protest against police brutality, and he was there. And also, the Floyd family spoke. Okay, well, so that gives a little bit of a theme here. Now, it's less about just general civil rights and more about protesting police brutality, which the question was, in fact, asking about. So now you can sort of say, well, maybe, in fact, he was lying. New photos from the event show demonstrators wearing BLM shirts, carrying flags, as well as signs that says, "I can't breathe," which Floyd repeatedly told police before he died. The march that he went to, August 28th, was specifically about police brutality. Criminal defense attorney Joe Tamburino, who is not associated with the case, told WCCO. In fact, it was partly advertised as Get your knee off our necks, and it had speakers with the Floyd family, Breonna Taylor, and Jacob Blake, which are, of course, all three victims of police brutality, of police incidents, however you want to characterize that. Breonna Taylor was shot and killed by police. Jacob Blake was shot, not killed by police. And George Floyd was, died at the hands of law enforcement. So they were all there, all speaking. Everybody knew what this was about. It wasn't just a civil rights march. It was more about police brutality. So what does that say about this juror? Did he lie on the questionnaire? March on Washington. George Floyd family urges protesters to be his legacy. All right. So here we have this one now posted over from the Washington Times, August 28th, 2020. And so this is back on that day, right? What is the 2020 March on Washington? Thousands of people gathered back in 1963 to do this. And this says called the Commitment to March, the Commitment March. Get your knee off of our necks. A reference to the death of George Floyd, who died in May. Sister of George Floyd, whose death in police custody sparked months of racial turmoil across the U.S., urged civil rights protesters to be his legacy. My brother cannot be a voice today, she said. We have to be that voice. We have to be the change. Floyd was one of several relatives of Black Americans harmed or killed. Speakers demanded racial justice at the event. So we know what the event was about. This juror knew what the event was about. He was wearing a shirt that had the name of the event on his body, which we're going to see here shortly. Jillian over on Twitter says, Was there a BLM plant in the Derek Chauvin jury? Brandon Mitchell, juror number 52 in the Chauvin case, was seen last summer, way before being summoned for jury duty, wearing a "Get Your Knee Off Our Neck" shirt with a BLM hat. Here is the juror. Is this a video? Let's see. Well, I guess that's not a video. So here he was on Good Morning America, back when we covered this previously. But a lot of the language that he was using was about, I wanted to get on the jury panel. I felt like I had an obligation to be there, and that other Black Americans, if you recall, the news anchor, who I believe was also African American, asked him something about that. Why is it so important that Black men are on juries? And, the regular question, or the regular, I think, sort of response would be, well, because we want a jury of our peers, right? That's what our justice system prescribes. It says you can be convicted based on a jury of your peers. And so if we have African-American defendants, of course we want some African-American people on the jury, so we have a racially diverse group, something that is representative of society, something that reflects society's demographics on the jury panel. Therefore, we have a cross-section of our peers. Don't want to go back to the 1940s where you'd have an African-American defendant commit some crime and a bunch of white jurors just say, well, that guy's Black, therefore we should convict him. Right? That was wrong then. Same type of concept is wrong. Jurors are supposed to, follow the law, follow the rules, and apply the law to the facts that they observed in a trial. You don't want it to be about, getting onto a jury panel and then making sure that you get the particular outcome that you want in the name of social justice. And so this gentleman, Brandon Mitchell, when he was on Good Morning America with that news anchor, she asked him, what? Why is it so important to get on there? And he didn't say, well, because we want to be representative. He said, well, in other words, we've got some things that we want to see happen in this country. We want some particular outcomes. And so we need to get on there so that we can have a voice, so that we can have a say. And the analysis, or the analogy I was asking you last week, ask yourself, does this man sound like a fair and impartial juror, or somebody who is close to an advocate, somebody who has a cause, a position that they want to see reality? They have an outcome that is desirable to them, and they're going to do what it takes to get that achieved. And this is what, essentially what it looks like Brandon Mitchell did, which is kind of bizarre. This person doing this might literally result in a new trial for Derek Chauvin. I'm going to show you the motion that Eric Nelson and their attorneys submitted today, about 30 minutes ago. So here is the picture that everybody is sort of talking about. This is the next generation being socially active, representing in D.C. my son Marzell, nephew Brandon Renee Mitchell, tagged, and brother with some hearts over here. So we've got, this is him, right? He's decked out. Get your knee off our necks, BLM. You see the two BLM fists here being raised up. We see an image of MLK. All right. Okay, we have BLM hat at the top here. And so he is just fully decked out in BLM gear. He's got it all. And he was somebody who was seated on the jury. Now, if you are not following attorney Andrew Branca over at Legal Insurrection or on Parler or on Twitter, I would encourage you to do that. Does great work, did an excellent job on the Derek Chauvin case. And he posted back on March 15th, day 6 of the jury selection. It's called voir dire. And so if we go back to his post, we can see what the process looked like for juror number 52, for Brandon Mitchell. So let's take a quick look and just do a recap. Then I want to show you the motion that was submitted this afternoon on behalf of Derek Chauvin regarding post-conviction motions and sort of asking for a new trial, because it's looking more and more likely now. If another juror comes out, oh gosh. All right. So this came over from Andrew Branca, and this, you'll notice, March 15th, right? So what are we talking about? This is when the 9th juror was seated. Okay, 3 others were said that we cannot be fair and impartial. They were excused. But on day 6, during voir dire, juror number 52 is seated. He's a youngish male. Obviously, the jurors are not being shown on camera. I had to speculate. I would guess that he was Black. Got that right. Was described as working in the banking industry, customer focus. Nothing much remarkable about the voir dire of number 2. That's the questions. He professed that he'd be willing to be fair to both sides. Judge the case only on the evidence and law presented in the court, even if he thought the law was wrong or should be changed, and that he could provide the defendant with a fair and impartial hearing, which is exactly the buzz phrase, right? That's exactly what you want the jury to say. Now, we all know that in August of last year, he was doing something totally outside of the tone of this, he was doing something where he was not impartial. He was an advocate for a cause. And again, I'm not saying that there's anything wrong with that. I support that. I am an advocate for a lot of things here on this show. I'm not upset about that one bit. What I am upset about is that he is so biased, obviously one-sidedly, that he then sort of manipulates the questionnaire on the during voir dire, during jury selection. And this whole thing now might come back to bite this movement in the butt if he does in fact get a new trial. So Nelson said, you wrote, I don't believe Chauvin intended to murder anybody, but having seen the video, don't know what reasoning would be. Can you listen to what people say about police training and police practice with an open mind as to what the reasoning could be? Juror number 52 said, yes, I'd like to know what the thought process would be. He also wrote in his questionnaire that he wondered why other officers had not intervened. When pressed by the defense to explore what this meant, he assumed that Chauvin acted wrongfully, indicated not necessarily so. He compared it to if he were driving somewhat thoughtlessly and a passenger prompted him to pay more attention. Someone can intervene even if what they are doing is not done with malice. So we have another question here. Nelson says, your impression of Officer Chauvin, did you form the opinion that he was doing something wrong? 52 says, I don't know that he did something wrong, but somebody did die. Even if no intention's doing something, somebody could have intervened and prevented that. I'm not paying attention and driving my car. So let's see what else. Prosecution passed for cause, so they wanted 52 on there. Number 52 became the 8th juror, and he said here, we can look at this from an objective point of view. And so we'll see where this goes. I want to show you this motion that has been submitted today. I want to show you this. We'll read through it here briefly. This was submitted at 3:59 p.m. So filed in Minnesota just this afternoon, May 4th, filed in district court, same court that we have been following along so far. It's defendant's notice of motions and post-verdict motions. All right, so now we know, let's frame this out a little bit. Trials ended, okay, trial was concluded, conviction on all 3 counts for Derek Chauvin. We saw him put in handcuffs and hauled out of court that day. He's not scheduled for sentencing, I believe, until early June, maybe June 5th. Already been some transport orders. They're going to bring him back from custody and bring him in front of sentencing, where the judge is going to determine what length of time he goes away for. And here now, we have something sort of in between those two things. We have the conclusion of the trial, sentencing is coming up, but they're already asking for new trials and wanting to make some pretty significant motions. So let's go through this. Here we have motions. Number 1, they want the following relief. What's the first thing they're asking for? An order granting a new trial. They're going to Minnesota law. They're saying that the interest of justice are proper grounds for this. Also, the abuse of discretion that deprived the defendant of a fair trial. They're also saying prosecutorial and jury misconduct, errors of law at trial, and a verdict that is contrary to the law. Well, that's a lot, right? The specific basis for this motion includes that the court denied the motion for a change of venue, saying that, well, this should have been a fair and impartial trial. A different venue would have supported that. The judge did not grant that, and the court abused its discretion as a result. They're also saying the court abused its discretion when it denied the motion for a new trial on the grounds that, quote, publicity during the proceedings threatened the fairness of the trial. Such publicity included post-testimony, but pre-deliberation intimidation of the defense expert's witness, from which the jury was not insulated. Not only did such acts escalate the potential for prejudice in these proceedings, they may result in a far-fetching chilling effect on the defendant's ability to procure expert witnesses, especially in high-profile cases such as Chauvin's and co-defendants. The publicity here was so pervasive and so prejudicial before and during this trial that it had amounted to a structural defect in the proceedings. And we saw this, right? Now, I don't recall the timeline on this, but we did see that I think there was a pig's head and pig's blood smeared across the house of somebody's residence. It was supposed to be one of the defense expert witnesses. I think officer, sergeant, whatever, Brode, I think was the witness. And somebody found his old address, went to his house and smeared a bunch of blood all over his door. So, whoever the neighbors were, or whoever actually owned that home, they had a bad morning when they went out to get the newspaper. But the point here is the judge did not move venue, did not sort of protect some of that stuff from happening. And the public opinion in the court of public opinion, there was so much volatility, so much anger and animosity that the question now becomes, will that spill over into the trial? Will that go and impact your expert witnesses? Will it impact your lawyers? Okay, we saw this back during the election litigation of 2020 when Donald Trump was trying to get a bunch of different law firms to help him out with his election litigation. Many of those attorneys were just sort of bailing, abandoning ship. They didn't want to work under the pressure. Same type of concept here. What if the public is so one-sided that expert witnesses just say, listen, I have an opinion on this thing, but it's just not worth it because somebody's going to come to my house. We know that there was another Derek Chauvin expert witness. I think it was Fowler, who is also, being sued. And so there's repercussions coming from the people who did step up and advocate on behalf of Derek Chauvin. And in the future, maybe people just don't want to do that. And then the defendant is really at a serious disadvantage just in terms of the availability of resources to help them win their case. This complaint goes on, and I wanted to show you this. Let's talk briefly about, we're going to get to the order here in a minute, I think. Okay, so here, let's go back to the motion. The court abused its discretion when it failed to sequester the jury for the duration of the trial, or at the least admonish them to avoid all media, which resulted in jury exposure to prejudicial publicity regarding the trial, as well as jury intimidation and potential fear of retribution amongst jurors. And we know this, right? Because we saw that the Dante Wright shooting happened right around the corner from where all this happened. There were protests taking place. One juror who turned out to be the alternate was traveling back and forth between the courthouse and Brooklyn Center where the protests were happening. So she was seeing a lot of this stuff. Same with other jurors. We had Maxine Waters, who flew in there, parachuted in from California to come and throw a bunch of stones at other people's houses. And the list kind of goes on, right? CNN, all the news people were there. Everybody was bracing for impact before the jury panel was even, before the jury was even sent to the deliberation room. All of this was unfolding for about 3 weeks during the entire trial. Judge didn't do much about it. Didn't even really warn them. City settled for $27 million. Maxine Waters came out and basically made verbal threats. If there's not a particular outcome, then she's going to be advocating for essentially violence. And you're going, what? Judge didn't even call people back up for voir dire. Didn't even ask them questions if they heard it. Says, oh, I already admonished them. And look, Cahill's got to do that at this point, right? Because the trial is over. What's he going to do? Say, well, all right, we just did this whole thing for nothing. We're going to do it again? It's tough. Rock in a hard place on this one. State committed pervasive, prejudicial prosecutorial misconduct, which deprived Chauvin of his constitutional rights to due process and a fair trial, but not limited to disparaging the defense. Remember, we saw that at the end when Blackwell was saying things like, they're telling you a story, right? Their fictional story or their narrative or whatever they want you to believe. He's sort of belittling their interpretation of the events. And Eric Nelson brought that up at the end, and it sounds like the judge admonished him and reminded him not to do that. They had improper vouching, and they have also failing to adequately prepare its witnesses. Court abused its discretion, violated Chauvin's rights under the Confrontation Clause when Maurice Hall didn't testify, or in the alternative, none of his testimony got admitted into evidence, right? So under the Constitution, you have a right to confront your accusers. And if people are accusing you of things, you have a right to present evidence to defend yourself. And so now we've got this really, really tricky commingling of rights. You've got Maurice Hall and his right to remain silent. You've got Derek Chauvin and his confrontational right, his ability to go and confront the people who are accusing him of a crime or who are involved in the accusations against him. Maurice Hall was in the car, could have been very, very closely related to the causation that actually killed George Floyd. We know that Maurice Hall historically had provided drugs to George and his girlfriend, and maybe he could testify about what George did. Did he ingest a couple of those pills that were right there in the front seat dashboard or what? But he didn't testify, did he? We also have this complaint saying that the court abused its discretion when it submitted jury instructions to the jury that failed to accurately reflect the law. The court abused its discretion in violation of Chauvin's constitutional rights to due process when it permitted the state to present cumulative evidence with respect to the use of force. So that means just bringing up expert after expert after expert. We had a lot of them all talking use of force. We had the chief of police. We had the LAPD sergeant. We had, I think, 3 or 4 people use of force. And I don't remember if Eric Nelson was objecting to this stuff, that it was cumulative. But, in law, you can't just say the same thing over and over 25 times. That's not a good argument. That is duplicative. It's too repetitive. And eventually people go, all right, right? And there's something that happens psychologically. I think during World War II, there was Goebbels, right? Somebody said, hey, if you tell a lie long enough, eventually people will believe it. It's like if you keep hearing the same thing over and over and over again, eventually you go, okay, that has to be it. And so that's what they're saying happened here. It was, in particular with the use of force, same evidence presented a bunch of different ways. The court abused its discretion, violated Chauvin's rights when it ordered the state to lead witnesses on direct examination. So that's just a questioning style. I'm not real sure how much I heard that or saw that stay out. Leading questions is sort of asking questions that guide a witness to the next point. So you can say, isn't it true that on March 1st you were here, right? And isn't it true after that date you moved over here? And isn't it also true that when you walked in you spoke to Mary, and it's also true that Mary said so-and-so about so-and-so, correct? Yes, and right. So you're asking them questions, but you're leading them through to the answer that you want, which is much more different than sort of an open-ended question, which is what you should have on direct examination. During a direct examination, you should say, okay, so tell me what happened on March 1st. They go off into the narrative. Well, I woke up, I had breakfast, I got my kids ready for school, went through the whole thing. And so, okay, what happened after that? You're not leading them. You're giving them the opportunity to fill in the blanks, versus on a cross-examination, then you are leading them, right? You don't want them to give you those big, long-winded answers. You want to say, so it's true, right? Yes. And they go, yes, but nope. Yes or no, right? And you narrow them down. Okay, so they're saying that this line of questioning, or this type of questioning, was allowed, even though it's impermissible. The court abused its discretion in violation of Chauvin's constitutional rights when it failed to order that a record be made of numerous sidebars that occurred during the trial. We saw that happen a lot. Cumulative effect of these multiple errors deprived him of a fair and impartial trial. An order for a hearing, so they want an order for a hearing to impeach the verdict on the grounds that the jury committed misconduct, felt threatened or intimidated, felt race-based pressure during the proceedings, and or failed to adhere to instructions. They also want an order granting the defense additional time to thoroughly brief the issues above in light of the time that was required for the preparation of partial transcripts of the proceedings. Any other relief. The motion is based upon files and records in this case presented here by, there he is, Eric Nelson, attorney for the defendant from Halberg Criminal Defense. So yeah, it sounds like right now they're preparing transcripts, right? Very long trial. They're going to beef all of those up. Eric Nelson's going to review them. What we just saw was sort of a notice letting the court know that there's more coming on this thing. We're just giving you notice that these are being filed, and they're going to ask for 60 days, 90 days, or the court. There's probably a rule in the Minnesota statutes that say, well, okay, we're gonna have arguments on this case in 90 days. Government, please brief your response to these motions. We'll see where it goes. So interesting, very, very interesting, and we're going to see if other jurors start trickling out. I mean, can you imagine if this whole thing has to start over again? Oh no. Pato in the house. Let's take some questions over from watchingthewatchers.locals.com. Pato's in the house. Says, hey Robert, love the show. It's looking more and more like this juror had an agenda and even lied to get on the panel. What at this point can be done besides the appeal process? Could the judge reject the verdict and declare a mistrial? Could Mr. Marshall be charged with perjury? I think that all of those things are possible, right? I think that yes, the judge could. We saw what Nelson was asking for. I'm not sure, it's hard for me to speak on some of the specifics on this because I don't honestly do appeal or post-conviction work in Arizona. And certainly I don't do it in Minnesota, but I know the nuts and bolts of it. But, each one of these things sounds like it is a reasonable outcome, right? The judge, as we saw in Minnesota, they called it impeaching the verdict, which would be going back and saying, this whole thing's tainted because a juror wasn't impartial and a juror did lie on a voir dire questionnaire. Now, if they're going to, so here's sort of the problem with this perjury question. The people who charge people with crimes are the prosecutors. Okay, the prosecutors in this case have a favorable juror who helped them get the verdict that they want. So is the prosecution going to now go and charge Brandon Mitchell with a crime? the juror that gave them the outcome that they wanted. Do you think that that's going to happen? I certainly don't. Robert, have you ever experienced jury misconduct? Are there criminal or civil penalties that apply in those instances? So they're typically admonishments. You know, you heard some of that during the Chauvin trial. I have never had jury misconduct. I can't even think of anybody in our firm that has, to the degree that it warrants something. I mean, there's always, you know, little problems here and there. Somebody's late, somebody's on their phone, somebody's not paying attention. It's sort of, you know, the kids are misbehaving in class type of gripes, not something that is, you know, that warrants a new trial or a post-conviction relief motion or anything like that, that I have personally seen. And we don't even get many calls about it. I mean, honestly, you know, people will call us about appeals, but nothing about jury misconduct. You know, it's always about something went wrong in trial that a lawyer did or that the prosecution did, but appeal cases almost never come in based on jury misconduct, in my experience. So not something that is particularly common. Besamiento says, can and should the juror be charged with perjury? He knowingly lied to the court under oath. You know, that's a discretionary call, right? You can make arguments both ways. You could take the crux of the question that was asked on the questionnaire, and you know, I think you can make a good argument that he didn't think that what he was involved in applied. Now, I think that is total BS, but I'm talking about this from a defense attorney, right? We all know what he did. He knows what he did. He even admitted it because he was on with Good Morning America telling the other woman about this. So, yeah, we got to do more of this, essentially. And so, you know, that is clear. But the prosecution, as I mentioned with the last question, they're the people who get to make that charging decision. And they're very happy with the outcome that he gave them. So, you know, there's another situation where this comes up a lot. In a domestic violence case, what often happens is it's a man and a woman get into an altercation. Police are called. They show up at the apartment. Guess who goes to jail? Want to take a stab at it? Yeah, it's the guy. Every time, 99 out of 100 times, the guy gets arrested. He gets, you know, brought into custody. All right, he gets charged with disorderly conduct, domestic violence, assault, domestic conduct, whatever, right? Even if she started it, doesn't matter. He gets charged. We go into court. We now set the case for trial. Case is ready for trial. Okay, this couple has, let's say, reconciled. The other party wants nothing to do with the case. They don't want, you know, they were angry the cops came to begin with. They didn't call, the neighbor called. Okay, nobody wants the police to show up at the situation. So let's say the female, who is the, quote, victim in this case, doesn't show up to court. Government doesn't have a key witness because their victim is not there. Nobody else was there. Neighbors didn't hear the fight. Neighbors didn't see anything. Police didn't see anything. They came after the fact. The whole thing was over by the time they got there. But when they show up, they got to arrest somebody. So somebody goes away. We get ready for trial. The victim doesn't come to court. What happens? She got a court order to be there. She's not there. Government doesn't have their witness. What do? They got to dismiss the case. They can't proceed without their witness. Cops didn't see anything. Neighbor didn't see anything. Defense isn't going to get up there and testify. So they have to dismiss the case. But what if the prosecution is really angry now that the victim didn't show up? That's their key witness. They didn't come to court today. So the next question then logically is sort of like what happened here with this juror. Does the prosecution that needed that victim to show up, do they charge her with a crime for violating a court order and not coming to court? 99 out of 100 times, no. Typically, no, unless it's a serious felony case, unless it's something that warrants that type of a response. But it's the same concept here, right? The prosecution in my victim case, they do not want to punish the victim. She's already been the victim of a crime, allegedly, so they don't want to add insult to injury, right? This guy, same type of situation, already on a jury, already, you know, did his civic duty, whatever, sat through a 3-week trial, made it on there, gave the prosecutors the verdict that they wanted. Do you think that they're going to charge him with a crime? No, of course not. We have no doubt, says Tim Poole said that the Floyd family spoke at the event he attended. Even with that, is this likely enough for the judicial system to reverse itself? So I think it's absolutely worth taking a very, very good look at this through the Court of Appeals. It's too early to speak on this quite yet. I would like to read the full brief that Eric Nelson's obviously going to be preparing. But yes, these types of things, in my opinion, are persuasive. They are powerful because it's obvious that you had somebody on the panel who was not fair and impartial. And the evidence is just, it's overwhelming, and it's It's not good. NY Renal MD says, I despise what Chauvin did. However, if the judge doesn't declare a mistrial, I feel a fair trial is a distant memory. The spirit of those questions is that we don't stack the jury with activists. Yeah, it's not about that, right? And you know, this is not an uncommon question. We talk about this in the law in the form of jury nullification. Okay, you can Google that, and you'll see that is a legal concept. This is a thing that people talk about. Now, judges won't let you do it, and you can't do it in the courts because they will flip because it's not allowed sort of in the court of law. But this is still something that people do. People will say, well, I don't like that law. It's called jury nullification. The prosecution hates this concept, but you could have the government present their entire case. Let's put this in the context of marijuana. Okay, let's say that you have a 12-person jury, and 3 of those people are ardent advocates of marijuana. They use it, plant-based medicine. They think it's great. Defendants is now being charged with a marijuana crime because in this jurisdiction, marijuana is illegal. So you might have those 3 jurors on there who use marijuana regularly. They're not happy that this law exists. They're not happy that this defendant is being charged with this crime because they think that the drug war is insanity and that prohibition doesn't make any sense. Okay, so that's fine. That's their personal opinion. They're free to think that. But if they try to impose that political disposition in the jury deliberation room, that's a huge problem. That's called jury nullification. They're not asked to apply the law as they deem fit or ask whether the law should be in existence or not. That's the purview of the state legislature and of our elected officials. It's not the purview of the jurors. The jurors are supposed to get in there, listen to the facts of the case, apply the law as written, regardless of your political ideology or whatever your opinions are on the case, and then come to a conclusion in that manner. So if you have, in this marijuana example, you have these 3 jurors who just say, oh, it's too bad, right? I think marijuana laws are stupid. And so we're going to vote for an acquittal here. Well, and on that basis, and that came out, the judge might order a new trial. Same thing, same type of thing here, right? The witness here, the juror here is somebody who is clearly biased in one direction. And we now know that. It's troubling. Liberty or Death says, here is a question. If by some long shot Cahill declares a mistrial or the appeals court remands, do you think the prosecutor would put him on trial again? Yes, I do. I think they would have to, and the change of venue would happen, but everyone knows what has happened at this point. Yeah, I totally agree with you, Liberty, on that one. I think that I'm not so sure that Cahill's going to get involved. If I had to guess, I'd say Cahill is just going to do as much as he can to send this upstairs. He did, I think, a great job running the trial to the best of his ability. Disagree with a lot of his decisions, but he was sort of dealing with an impossible situation. So I think he ran it the way that he ran it. He's going to send it upstairs. We'll see what the Court of Appeals does. I'm very excited to see what the government says in response. This is going to be interesting because this is sort of kind of a case of first impression. We've had very, very important, popular national cases in this country before, but this one sort of had the entire media and most of the elected government officials all in alignment rowing one direction. And when that happens and you have a conviction on all counts and then you have some juror malfeasance or at least some improprieties happening here, maybe this works its way up to the Supreme Court and they tell us how to deal with this stuff because this is going to happen again. We got Kim Potter's case. We've got a lot of other ones that are going to be coming down the pike, no question. Next up, we've got HLB says, defendants get innocent until proven guilty, right? Supposed to. So does the jury not get assumed to only have facts of the case in mind unless proven to be an unbiased plant based off of the actions and words while being a juror? Wait, does anyone oversee juror deliberations or possible past connections to assure no planted jurors? Boom, more American jobs. So HLB has a stimulus plan here. Boom, more American jobs for juror deliberation overseeing, which is, so kind of yes and no, right? There are other people there who are, helping facilitate the deliberations. But no, there's nobody in there like a judge or a bailiff, guiding the deliberations because we don't want the system involved in the deliberations. We want the jurors to deliberate. We don't want a judge to walk in there and tell the jurors how to deliberate because they'll just defer to the judge, And we don't want that. We want the jurors to decide. We have Anki Woe says, given the BLM juror, it now makes an even more difficult challenge to get an impartial jury, because even if there is one juror secretly sympathetic to BLM, that juror would be able to comprise the identity of any disagreeing juror post-verdict and bring the destructive mob to the person's homework and destroy their life. Ooh, that's a good point, right? Yeah, you sort of get somebody on the inside, and that somebody on the inside can communicate who the rest of the makeup, who the rest of the jury is, so that external pressure can come to bear on them. Yikes. I don't know what that does to the justice system, but doesn't look good. All right, we've got last one in the House. NY Renal MD says, how about the judge charging him with contempt of court? In that case, it can be outside of the AG's office, right? Yeah, so the judge, yeah, that's a good point. I think the judge could charge him with contempt, hold him in contempt, and penalize him that way. I think the judge could do that. It's a good point. I didn't think about that one, but that's a good point. All right, good questions. All of those came over from watchingthewatchers.locals.com. Thank you so much for your support. Really appreciate it when you go over there and help us kind of keep things on the track over there. It's a great community. Ask questions. Download a free copy of my book. Get promo codes for everything. It's good stuff. watchingthewatchers.locals.com. All right, so we're going to change gears, and we're going to have to pick up the pace just a little bit. We're talking about critical race theory. In particular, there is a lawyer, goes by the name of David Pivtorak, who is filing a lawsuit against the government of California over CRT, specifically saying that California, your hiring policies are discriminatory and they're unconstitutional, and we're going to do something about it. So we want to go through this. We spent some time yesterday talking about critical race theory. If you are not familiar with this concept, I'd invite you to go check out that show, or at least that segment. We should have that clipped up by now, but comes over from an article from a guy named James Lindsay at newdiscourses.com. Gives a very nice summation, 2-page summary of what critical race theory is. And it's important. You're hearing it all over the place. You're seeing this sort of pervade itself into all the different facets of our life, and including our government, including in California. And so I want to go through this. We're going to have to go through it relatively quickly, but I want to show you what it looks like and what some of these issues that we're arguing about. Let's get into it. So as we see here on Twitter, David Pivtorak says, we have filed our opposition to the California government's motion to dismiss our critical race theory class action. So what he's talking about, he is forming a class action, which is a large number of complainants, so people who have a common cause or common complaint, bringing them together, suing California. California now filed what's called a motion to dismiss. They said, no, you don't have any basis for bringing this lawsuit. What are you guys, nuts? So what he's talking about is the response to the motion to dismiss. So let's take a quick look at it. He says, when we tried to stop them from using racial preferences in hiring and promotions, they filed a motion to dismiss under California's onerous anti-SLAPP law as an intimidation tactic, using the threat of adverse attorney's fees. This is why we need your help. Please donate so that we can match the government's resources and win this litigation battle. Court documents are in the link. So if you want to go support this gentleman, check him out at Piv4Law, PIV4Law, over on Twitter. And if you go there, you'll see a direct link to the GoFundMe that he's referencing. I think we have a screenshot of it here shortly. So I want to take a quick look first. I think this is the motion to dismiss, the response to the motion to dismiss. So California says, you can't sue us over CRT stuff. This is nonsense. We want to dismiss. Here's what he says back. The sole purpose of this action is to affirm the principle enshrined in law that, quote, basing present discrimination on past discrimination is obviously not right. For decades, the state of California has embraced merit-based, colorblind policies with regard to its employment practices. These policies prevent government officials, no matter how well-intentioned, from attempting to manipulate the racial demographics of their workforces. Defendants who lead California's largest state agencies bemoaned these race-neutral policies and their own agencies as, quote, institutionally racist. Okay. Simultaneously, they accused white employees of benefiting from and perpetuating the, quote, systemic inequity that has led to their overrepresentation in the workforce. Defendants use this to justify their implementation of thinly veiled racial quota systems that seek to correct this imbalance. Hear that language? We talked a lot about this yesterday. White privilege and white this and white this, right? White employees, racial quotas, institutionally racist, systemic inequity. Okay, color. All right. Plaintiffs filed the instant action to enjoin defendants' race-conscious employment policies, which violate state and federal law. So the class action, the plaintiffs are suing to stop them from using these policies in their hiring decisions. Defendants' anti-SLAPP motion fails because its strained reading of the complaint misrepresents what plaintiffs allege as the basis for the government's liability. The complaint's first sentence states that this class action seeks to eliminate discriminatory policies and customs in California state agencies that institutionalize racial preferences. It is made clear repeatedly throughout the pleading. The basis of the lawsuit is not the defendant's speech, but their implementation of racially discriminatory employment policies. So what does all this mean? The SLAPP stuff in California, it's free speech stuff. We've talked about this, right? Basically, you have certain protections, and if somebody is suing you in the SLAPP context, I'm having a difficult memory blank remembering what we were talking about what context we were talking about that in. But it's essentially free speech, and if somebody is suing you, like filing a cease and desist or filing a lawsuit, in order to chill your speech, in order to stop you from talking, there are rules against that. You can't just do that. You can't just be a billionaire. Somebody makes a YouTube video, you sue them for saying something that they're lawfully entitled to say, and you want to just try to silence them. Well, there's rules against that. You can't do that. You can't sort of use the legal system as a sword to infringe upon somebody else's protected ability to speak. And here, the government is saying, well, that's exactly what they're trying to do here. They're trying to say that what we're doing is bad because it's just language. We're using things like institutionally racist and systemic inequity and blah, blah, blah. They're saying, the government is saying, they're attacking our free speech. They're attacking our ability to communicate these ideas to our workforce. And the class action is saying, no, we're not. We don't say whatever you want to say. We don't care about that. We care about the implementation of these policies. We care about people who might want to work for you, California government, and you say, no, we can't hire you because you're white, and we have these thinly veiled racial quota systems. That's the crux of the suit. It's nothing to do with the speech. The speech is problematic, sure, but it's about what the policies are that you have enacted in California. So it says here, even so, plaintiffs, so the class action lawsuit sufficiently establishes the likelihood of success on the merits. There is no question that defendants' attempts to socially engineer the racial composition of their workforce violates California and U.S. Constitution. During California's affirmative action period in the 1980s, plaintiff faced rejection while applying for employment at the Department of Game and Fish based purely on his race. Now, because of California's policies, he is once again faced with the prospect of this indignity in applying for a promotion he desires. This is precisely the type of situation the law is meant to address, and defendants' abuse of anti-SLAPP statute to cynically intimidate an employee with a looming threat of an adverse attorney fee award is not something the legislature ever intended when passing the law. So this guy files suit, they respond back and say, oh, you're suing us? How about this? How about we rely on this free speech stuff? We're allowed to say whatever we want because we're the government. And if you sue us and lose, we're going to ask for attorney's fees. We're going to come down. We're going to, with the weight of the federal government, or the state government here in California, and we're going to make you pay for all of this litigation that you have incurred. They're saying that's ridiculous, okay? You're not allowed to, just like the anti-SLAPP statutes prevent somebody from doing that to you as a sword, you can't use the statute itself as a basis for also using it as a sword, claiming that you can get attorney's fees. So this is the GoFundMe. You can see here, class action to stop discrimination in California government. So if you want to support them, go give that a shot. It says this class action seeks to eliminate discriminatory policies in California. Shortly after the national upheaval stemming from the death of George Floyd, the heads of California's largest state agency started engaging in racially divisive messaging to their employees. White employees at these government agencies were told that they were guilty of bolstering systemic racism and, quote, white supremacy purely based on the color of their skin. These agency heads also accuse the employees, civil servants who have dedicated their entire lives to protecting California's resources, of, quote, perpetuating the violence of the system if they did not engage in their boss's preferred method of political activism. Talked about this all day yesterday, right? We went through that item by item, and the language there, that is being promulgated by the critical race theorists is this idea that if you are not actively anti-racist, then you are necessarily racist. In other words, if you are not out there every day screaming from the rooftops, that's racist, you're a racist, this guy's a racist, that car's a racist, that sandwich was racist, that doorknob's racist, then you are also a racist by negative participation, by not claiming that you're anti-racist or by not actively participating in anti-racism, you are a racist. And so California government apparently is doing the same thing. Using the accusations as a backdrop, the agency heads announced the implementation of work policies that are rooted in critical race theory. Policies intend to institute racial quotas into hiring, promotion, and other aspects of employment in violation of the law. State government, represented by the California Department of Justice, is going to throw its nearly limitless resources to stop this lawsuit and allow these unlawful policies to move forward. So if you want to go and support them, you certainly can. I want to show you the original lawsuit. This looks like this was filed back on October 13th. And this is submitted, as we know, by David Pivtorak, right? California bar number, Pivtorak law firm out in California, filed October 13th, 2020. So this guy's been working on this for some period of time. You can see here, this is a complaint for declaratory and injunctive relief and damages. So what are they asking for? We have Guy or Eisen, individually on behalf of others as taxpayers, also suing the Director of California Department of Fish and Wildlife. And what else do we have? Okay, so declaratory. So the lawyer is asking the court for a declaration that the policies that are being used here are not lawful, unconstitutional. Also asking for an injunction, which is the fancy way of saying that we want you to tell somebody to do something. We want you to require that they take one particular course of action. In this case, very likely, we haven't gotten to it yet, but very likely stop using these policies, stop hiring and stop having conversations with employees and based around critical race theory. And then, of course, they want damages. So damages would mean money, anything that was lost. Anybody who was supposed to be promoted and was not, well, they suffered some damages. They suffered the difference in pay that they would have received in their new position. They don't have that, obviously. So there should be some compensation for that. So let's take a quick look at the lawsuit. We're going to go through this relatively quickly, like I mentioned, see if we can sort of tease out what's happening here. This is the preliminary statement. As we know, seeks to eliminate discriminatory policies. Defendants are Wade Crowfoot and Charlton Bonham. They are acting Secretary of California Natural Resources Agencies. They've implemented policies called critical race theory. So these are the people who are being sued. After the national upheaval, after George Floyd's death, they made these changes. The introduction, the essence of critical race theory is the promotion of racial homogeneity and resentment towards people of, or homogeneity, is that what I said? And resentment towards people of different races. In order to understand the discriminatory nature of California's conduct, it is crucial to understand what CRT is and how it manifests itself. Began in the 1970s as a study of law as it pertains to the issues of race. Its stated goal was revolutionary political change and repudiation of the idea that the Constitution and law would adequately address racial problems in society. We talked about this yesterday. The revolutionary approach, right? Everything is racist. You have to call everybody racist in order to create this division, in order to create some separation that will spark a revolution, that will spark some cataclysmic changes in this country. Because if the entire system is racist, if the entire system is systemically racist, well, you got to get a new system. You can't fix that, right? If the house is falling down, you can't prop it up with some duct tape. You got to knock it down and build a new one. That's what they're advocating for here. They're saying that we need dramatic change in this country. The only way to do that is by creating more division. Critical race theorists, we have Richard Delgado and Gene Stefancic in their seminal text called Race Theory describe it as such. We've already read through a lot of that yesterday. The overarching principle is that racism is not aberrational in society. It is the status quo. It means every human interaction, the question is not did racism occur, but how did racism occur? Talked about that yesterday. The term systemic racism often used interchangeably with white supremacy. They also talk about that any white benefit comes from oppression, which is dubbed as white privilege. All right, this isn't a court document. We have, according to the CRT, all white Americans are racist, regardless of who they are and how they behave. They are complicit in upholding white supremacy. The term silence is violence originates from CRT. There is no neutrality, no just being a good human being. Any white person not engaging in CRT is declared to be complicit in perpetuating white supremacy. California proliferates these ideas by explicitly accusing class members, civil servants that have dedicated their lives to California, of, quote, perpetuating the violence of the system. Defendants also use the, quote, silence is violence canard against class members, indicating that unless class members buy into and engage in a specific type of political activism that the defendants support, that California supports, that class members are as guilty as those who commit actual racial violence. Actual racial violence. If you don't say anything, it's the equivalent of actual racial violence. More systemic racism. We have diversion, inclusion, and equity doctrines. We have that going on. Let's see what else. While technically rooted in CRT, the DIE industry, what is that? The diversity, inclusion, and equity is DIE. Let's read this one. After accusing class members of engaging in violence, if they do not ascribe to California's racially diverse ideas, defendants' communications propose to implement a plan of atonement, putting in place training and hiring practices that implement CRT-approved loyalty oaths and racial quotas. In CRT, this is what is referred to as DIE, diversity, inclusion, and equity. You think they could have come up with a better acronym than that? Hey, we're going to teach you about CRT. Oh, what are you going to teach me? Well, we're going to give you the acronym. DIE. Huh? Like the country. All right. So they say, as explained above, while the terms carry a certain meaning to the average person, they mean something entirely different in CRT terminology. The word equity in DIE initiatives does not mean equality of opportunity for all, regardless of immutable characteristics. Instead, it means specifically the use of racial quotas to achieve representation of racial groups in proportion to their overall percentages in a given population. Talking about equity and inclusion questions in interviews. Defendants justify the implementation of their unlawful race-based policies by following a dialectical structure that mirrors CRT's indoctrination methodology. And we talked about this yesterday. Remember where I was saying that this is such a beautiful concept, a theory, because anything that you say to combat it, you're a racist. It's like judo. Use your opponent's energy against them. Topsy-turvy, the whole situation. Now, if you say, hey, your CRT theory is stupid and this is asinine, doesn't make any sense, you know what they say? Oh, you're a racist with white privilege. Yeah, of course you don't know and understand this because you are basically contributing to the patriarchal hegemony that exists in society. So I hope you sleep well tonight. Robert. All right. Says first, how does this work? How do they indoctrinate you with CRT? First, defendants bring up examples of isolated incidents that they claim without evidence are rooted in racism. Can you think of any of those? Basically everything. Isolated incidents they claim without evidence are rooted in racism. Literally everything. Everything. Somebody holds up their hand on Jeopardy, racist. Whole country needs to stop and pause as all the media starts to hyperventilate over that. Clearly racist. Second, defendants use those incidents as proof of their conclusory allegation that any racially disparate outcomes in society are product of racism, even when the claims are belied by empirical evidence. Everything is racism. Third, they propose to, quote, dialogue about the issues while making it clear that any opinions opposing the narrative will be met with retaliation. Fourth, defendants propose to implement DIE in their agencies through the means of race-based hiring, promotion, and other terms and conditions of employment. We're very familiar with this stuff. This is going on in California now. Take a quick look at what's going on. June 4th, 2020, defendant published an email, so this is California, to all employees, insinuating that white employees should recognize their, quote, white privilege. So this is somebody from the government sending an email talking about white privilege and demanding that employees view every incident between people of different races as evidence of targeted acts of systemically racist violence and oppression. Imagine getting an email like that from your boss. You're just a white guy working. Hey, I'm just, typing some emails. Hey, having a good day. Oh, well, my boss sent an email. I wonder what defendant Bonham has to say. Oh, open it up. Email says, hey, Robert, you white racist. Anytime you get into a little conversation with anybody here at the office, you piece of garbage, I want you to think about how you're contributing to targeted acts of systemically racist violence and oppression because of your white privilege. I'm just answering emails here. I don't know what you're talking about. White privilege, there it is. Bonham states that his decision to publish the email arose directly from a CRT inspired thought process, an article to white organizational leaders that said silence is violence. Stupid catchphrases. The email itself strictly follows CRT programming, perpetuating the violence of the system, blah, blah, blah. Bonham's invitation to build a culture of dialogue. Yeah, right. Meaning what? Read in light of the tone messaging of the rest of the email, which demands that employees recognize their privilege and accept CRT's politically biased vision of America as a hopelessly racist nation, make it clear that the only dialogue that is acceptable is the one that includes CRT-approved talking points that are openly hostile to white employees strictly due to their race. That is the definition of inclusion in CRT's DIE programming. Folks, if you haven't donated to this legal cause, this is probably a good time to do that. Let's see what else we have going on. They have a nice little summation here. First, the speakers engaged in selection bias of isolated incidents as proof of systemic racism. So what are these isolated incidents? Defendants, Crowfoot, let's say, America has a mental illness. White supremacy is a mental illness. It manifests itself in so many ways. We are all susceptible to it. You have to recognize that even if you're a liberal, even if you support progressive causes, that doesn't mean you don't harbor racist views because of the society we've grown up in. The default of white supremacy exists in America. Who's saying this? Crowfoot? Participate in Crowfoot's Secretary Speakers series. So Crowfoot. Oh my God. Too many people to keep track of here. Let's see what else we have. All right. We got some questions coming in over from watchingthewatchers.locals.com. Let's see who's up first. 2A all day, every day says all it means is it's about indoctrination. Yeah. Very clearly. Right. And it's bizarre indoctrination. And it'd be hard to be an employee, honestly, at one of these places. And just sit there and be told all day, you're a racist, you're a racist, you're a racist. Everything you do is racist. And if you don't agree, you're even a double racist and a triple racist. And if you don't speak up, you're a quadruple racist. It was like, all right, I'm out of here. Speech Unleashed says, can the U.S. Supreme Court rule these type of state policies as unconstitutional across the board? Yeah, they certainly could. They could say that this violates equal protection under the 14th Amendment easily, right? Or a number of other different provisions that I think are probably found elsewhere in the laws, in employment law and other civil rights statutes, but certainly, right? Equal protection. One particular group is being villainized and demonized relative to another group. That's not equal protection under the law, not in any way. 2A all day, every day says, isn't this just a rewording of the affirmative action that was shit canned years ago? Yeah, it is. Essentially, it is. But this is a little bit more, I would say, aggressive, right? Affirmative action was sort of about, fairness. Well, we're just trying to even things out a little bit. We want to give some other people some cultural boosts a little bit. We'll just sort of, even the ability for equal opportunity. This is not what we're talking about now. We're talking about the equity of the outcome. Now we're talking about demonizing and actually, in my opinion, being actively racist against certain races in this country, like explicitly in writing. But what do I know? I'm a white person. I don't know anything about race. I'm just ignorant to this whole thing. I have no opinions. Nothing I say is valid because of the color of my skin. Other people have judged that to be the case. And as we all know about judging people on the basis of their skin color, perfectly acceptable thing to do these days, because obviously the CRT theorists are doing it every day, as we see in this court paper. Sharon Quidney says, in spite of empirical evidence, don't you just love these folks? It's all about the science, folks, dismissing empirical evidence, which is essential to scientific inquiry. There's not too much about that in this concept. This is about I think serious levels of indoctrination to the point where people increase the division in this country such that it prompts strong calls for action that is in alignment with their stated end desires. Anki Wo says, if race-baiting hiring is good enough for Biden, must be good enough for California. He announced he would select a woman of color for VP because gender and color shopping is somehow acceptable in practice now. Yeah, I mean, it literally is like that, right? We saw yesterday the CIA had the Latina woman saying, I don't check boxes. My life is more than just a box checking exercise, is I think her exact quote. And she then spends 2 minutes and 18 seconds checking all of the boxes. I'm a cisgender, a millennial. I've got generalized anxiety disorder. I got kids. I can speak Spanish. I can speak English. That's where this is going now. You just have to sort of have the right racial makeup and gender parts. But I don't know that matters though anymore, because you can kind of just change them at every turn. Last question on this segment comes over from HLB. Says, this is not giving up vibes of how they want to convict people of stuff based on their social media history when that goes public. Just kidding. That would get politicians messed up. Just kidding. They would hide it. And this sort of stuff never applies to the powerful. Well, we talked a little bit about this CRT stuff yesterday, HLB. And I think that there was a good sort of a synopsis of what this means and to whom. In particular, what is the critical race theory? What does that do for people? What does it do for the people in power? What does it do for the billionaires and the top 1%, for the CEOs, for the CIA, for the FBI, for any of our government people? What does it give them? Well, it gives them a lot of talking points, right? They can get behind this one way or the other, and they can rant and rave about it all day. Meanwhile, all of the little people, the people like me who are, on YouTube and elsewhere arguing about these things, we're all just sort of wasting our time talking about locker rooms and gender pronouns and, who can do whatever with whom and whatever bedroom, which way from Sunday. No, I just don't particularly care about. But it is making sure that we're all not focused on some of the more important things, like, $4 trillion in new spending. How about that? How about inflation that Warren Buffett and many others, including the Federal Reserve, say, well, it might hit us like a sack of bricks come September and beyond in Q4. So, there's a lot of other things that we could be focused on. We could actually talk about justice reform, like meaningful justice reform. Or we could talk about, racial inequity, white privilege, systemic racism, and all of this crap that is meant to be divisive, not meant to be solution-oriented, which is what makes it so frustrating. All right. So thank you for those questions. Once again, came over from watchingthewatchers.locals.com. And we've got one more segment to wrap up. We've been talking a lot about the CIA and the FBI because, they're kind of everywhere. They're spying on us every which way you turn. And they kind of are just becoming a problem. The people that they should be investigating, they're not. The people that they are investigating, maybe they shouldn't be. And around and around we go. So we've got two stories. One weird thing happened yesterday. I don't know that there's anything consequential here. Could have just been a weird thing. But anytime you have a gunman who is shot and killed at CIA headquarters, you got to just take a closer look at that, right? Is it Jason Bourne here? Is James Bond back in business? Who's got eyes on Pierce Brosnan? All right, so let's take a quick look at this story because it's kind of interesting. Over at the CIA headquarters yesterday, an armed suspect dies after being shot outside. An armed suspect was there at CIA headquarters in Langley, Virginia yesterday. NBC News reported that the person was stopped at the entrance gate by armed guards after trying to enter the facility without permission. FBI confirmed in an initial statement on Twitter on Monday evening that a person was wounded. The incident is currently under investigation. FBI is reviewing an agent-involved shooting that occurred at approximately 6 p.m. on Monday. The tweet said, individual involved in a security incident outside CIA agency HQ in McLean, Virginia, emerged from his vehicle with a weapon, was engaged by law enforcement officers. The subject was wounded, has been transported to a hospital for medical attention. The FBI takes all shooting incidents involving our agents and task members seriously. Review process is underway. In an updated statement on Tuesday, FBI confirmed that the man died from his injuries after being transported to the hospital. They're set to review the shooting incident. Earlier in the statement, the CIA confirmed the agency was responding. They say, in coordination with our local law enforcement partners, we are addressing security situation just outside the secure perimeter of CIA headquarters by our main gate. Our compound remains secured. Our security protective officers working the incident are the only agency personnel directly involved. According to local media, the situation led to road closures in the area. Fairfax County Police were helping to direct traffic around it. So, interesting. Could have just been a one-off, kind of a crazy person, but CIA headquarters. Tom Cruise rappelled down in there and hacked the system. Pretty impressive guy. All right, so what else is happening with the CIA and the FBI? Well, of course, they're spying on you and me and everybody that they want to, because there are no repercussions for it. Well, Jim Jordan and Andy Biggs are two House representatives who are asking some pretty hard questions about it. Want to go through this. We're going to be talking about the FISA court, the Foreign Intelligence Court, and the Foreign Intelligence Surveillance Court. I've got two definitions for you. We're going to go through them. Let me frame this out here quickly. We're going to go to Fox News. It says that Jordan and Biggs demand answers from the FBI on widespread FISA violations after declassified FISA court opinion. FISC stands for the Foreign Intelligence Surveillance Court. The FISA stands for the Foreign Intelligence Surveillance Act. So we're talking about FISA is the entire act. The court, FISA court, deals with the cases. So House Representatives Jim Jordan, Andy Biggs, they're demanding answers from FBI Director Christopher Wray, which is going to be a long wait because he doesn't have many of them, after a newly declassified opinion from the FISA court revealed that there were widespread FISA violations. So, all right, what are we talking about? The FISA court, or the FISA Act, is foreign intelligence. I have a slide on this here. Republicans throughout the Trump administration were vocal about abuses of FISA after the FBI obtained the FISA warrant against Trump campaign aide Carter Page. But last week, Office of the Director of National Intelligence, the DNI, declassified an opinion from the FISA court with oversight from the FISA system, which is what we're talking about now. All right, so the Foreign Intelligence Surveillance Court, what is it? The court was established by Congress in 1978. The court entertains applications made by United States government for approval of electronic surveillance, physical search, and certain other forms of investigative actions for foreign intelligence purposes. So what happens here? The government in charge goes to this special court called the FISA court and says, hey, we've got these people over in Iran that we want to spy on. They've got some information that's critical to national security. Okay, so they go to the FISA court and they say, we need to do this. Here's why. It's a special court that's set up to authorize those foreign surveillance activities. Now, the problem here is when that person in Iran is communicating with somebody in the United States. They pick up the phone, they call into the United States or email or whatever, and the FISA court now has granted permission to spy on the person who is the foreign individual, the foreign asset, the person in Iran. But what about the person here in the United States who happens to be a U.S. citizen? Do they have the ability to go and listen to their conversations? Because they're a citizen here in the States. They have certain constitutional rights against government intrusion, and we want to maintain that. We want to protect that. Now, the people who are not here, who are in Iran, they don't have those same protections. So how do we balance these things out? Well, one of the things that they do is called masking, so that they sort of scrub out the identities of the people who are on the U.S. side, which is what's supposed to have happened with many of the Trump administration officials, including General Michael Flynn. Problem is that a lot of those individuals were unmasked by the Obama administration, which led to the whole Carter Page and this whole thing that's been going on with the FISA problem for a long period of time. So now there was a newly declassified memo. The FISA court came out, declassified this memorandum, and they're saying, oh yeah, you know those concerns that you had about the FBI using the FISA court to not only spy on foreign assets, but also American assets? Remember when they were sort of looking at American people as well in violation of what some of the laws and rules say? There was a lot of that going on, actually. And so here we're just going to let you know about it, that this may have been a little bit more prevalent than otherwise suspected. And now Congress, of course, is not happy about this. Now, quick overview on the FISA court and the Surveillance Act. It says here it's a federal court established and authorized under the Foreign Intelligence Surveillance Act of 1978 to oversee requests for surveillance and warrants against foreign spies inside the United States by federal law enforcement intelligence agencies. Such requests are often made by the NSA, the FBI. Congress created the FISA and its court as a result of recommendations by the Senate's Church Committee. From 1978 until 2009, the sixth floor of the DOJ building. It's been moved over to the courthouse in Washington. In 2013, a top secret order issued by the court, which was later leaked to the media from documents culled by Edward Snowden required a subsidiary of Verizon to provide daily ongoing feed of all call detail records, including those for domestic calls to the NSA. So we've got all these alphabet agencies working with each other, passing the buck around. Edward Snowden broke the story, and now there's investigations going on. Well, what was this FISA court doing? We know that they were supposed to be authorizing surveillance of foreign spies, but what about American citizens? Well, Snowden told us that they were doing that all over the place. And now a new opinion came out from the FISA court saying, this was happening very often. So here is the letter from the Congress of the United States, the Committee on the Judiciary, from the House of Representatives. This is going over to Director Wray. This was authored by Reps Jim Jordan and Andy Biggs. Dear Director Wray, this letter was drafted today and sent over their direction. According to a recently released opinion from the FISA court, the FBI has been seriously and systemically abusing its warrantless electronic surveillance authority. April 26, 2021, the DNI, Director of National Intelligence, declassified a 67-page FISA court memo opinion and order from 2020 detailing the FBI's apparent widespread violations of privacy rules in conducting surveillance under Section 702 of the FISA Act. We write to request information about the FBI's illegal spying activities. Now, I know many people just say that this stuff, whatever, right? Everybody's spying on you. Phone has cameras all over the place. Every single app says, hey, we want permission to access your DNA. And you say, yeah, no problem. Everybody else has it, so who cares? This is a pretty important part of our justice system. It's restraining the federal government. You may be okay with Facebook, and Google having stuff all over your house, but when the government does it, and the government has the power to incarcerate you and literally rob you of your liberties, this is a problem. And we got to make sure that we hold the line on this thing, okay? Government has to abide by the Fourth Amendment and the rest of the Constitution, lest we all suffer the consequences. Section 702 authorizes the Attorney General and the DNI to jointly authorize warrantless surveillance of non-U.S. persons reasonably believed to be located outside the United States, subject to limitations. That's what 702 is for. So, for example, 702 says that the adoption of, quote, targeting procedures to ensure that 702 acquired information is limited to non-U.S. people to prevent intentional acquisition of U.S. domestic communications. So what they're saying is Section 702 provides a mechanism whereby people who get sort of swept up in these conversation dragnets where they're gobbling up all this information from foreign surveillance communications, if they identify U.S. citizens, then there are certain rules and provisions and procedures in place to limit the identification of those individuals so that we can protect the U.S. citizens from warrantless access to their information. All right, because this is coming from the FISA court, not from a domestic court. This is a specific jurisdiction for these types of issues. In its November 2020 opinion, the FISA court reported the FBI violated the querying standard following a Department of Justice audit about their compliance. The court determined the FBI had misused its surveillance powers, finding that the FBI's failure to properly apply its querying standard when searching for acquired information was more pervasive than previously believed. The FISA court noted that the FBI official responsible for limited background investigations conducted over 120 queries of 702 acquired data using names and other identifiers of individuals who had requested to participate in the FBI's Citizens Academy, a community outreach program. FBI also queried names and identifiers of individuals who needed access to an individual field office for office repairs and others who sought to report tips. Other violations involved FBI personnel who failed to opt out of querying raw FISA acquired information for reasons that did not meet its intent, such as the FBI analysts who conducted more than 100 queries for analytic paper. So you've got this computer system that has just massive amounts of data and information that you have very, very, strict. I think we saw this in some of the Edward Snowden movie, right? There was the Hollywood remake or interpretation of the Snowden debacle, and kind of goes and he says, well, what do you need? I got this terminal here that I have access to the backbone of the internet, to every single bit of data that's been transferred since the beginning of time. It's all right here. What do you need? Give me a name and I can tell you everything about the person. So, this happens a lot. We see this with misdemeanor cases where police officers who don't have access to certain evidence go and get access to certain evidence. Why? Well, because they're in a position of power and there's nobody to oversee them. FBI was doing the same thing. There's this database There's supposed to be protocols and rules in order to access that information because it's protected, because it's constitutionally sacred information. We've deemed it to be such. FBI just kind of, go look around. Hey, I wonder what Jenny's doing today. Type Jenny. Okay, there's Jenny. New boyfriend's a loser, right? It's that type of stuff that human beings do. FBI's not immune to it. We've got the FISA court further documented the government has reported numerous incidents regarding searches of FISA information without first obtaining court permission. So just doing it without even going to the court. The FISA court noted the discovery of 40 queries in which the FBI accessed information for investigations involving healthcare fraud, transnational organized crime, violent gangs, domestic terrorism, involving racially motivated violent extremists, as well as investigations related to public corruption and bribery, all of which were unrelated to foreign surveillance. FBI, domestic law enforcement agency, looking up for FISA information to use it in their domestic law enforcement sourcing, even though they don't have permission to do so from any court. They're going through the FISA courts because nobody's watching them. These concerns are particularly disturbing in light of prior FBI misconduct thoroughly detailed by the DOJ, suggesting a pattern of abuses and deficiencies in the FBI's FISA process. In December 2019, an OIG, Office of Inspector General, issued a report finding the FBI had abused its FISA process to illegally surveil American citizens associated with President Trump's campaign. Footnote 14 sends this over to the Department of Attorney General's Crossfire Hurricane investigation. Remember that phrase being bandied about? We know that the FBI has been botching this stuff for a long period of time. The recently released FISA court opinion raises more questions. Jim Jordan and Andy Biggs, they want to know, please explain why almost a year after the OIG report about FISA abuses, the FISA court found the FBI to still be abusing its warrantless surveillance authority. Why? Please provide a detailed accounting of every instance since December 2019 in which the FBI has queried, accessed, otherwise used information obtained pursuant to Section 702 purposes unrelated to national security. And number 3, please explain what actions you have taken in the wake of FISA court's November 2020 memo in order to prevent the FBI from using its authority to investigate U.S. citizens, signed off on by those two gentlemen. We'll see what Director Wray comes back with, the FBI guy. We'll see if he has anything useful for us. Remember, it took him like 4 months to tell us how Officer Sicknick died. We'll see what we get. Liberty or Death says, I hate the idea of having FISA. The Chief Justice of SCOTUS appoints the judges. No confirmation process, is secret. You can be under surveillance and never know. Disgusting process. Liberty is 100% right. What happened to the Trump campaign is proof we should not have a secret court like this. Too easy to abuse. I agree, which is why I'm always screaming about accountability and transparency. We have to see what's going on because when the government puts this stuff behind closed doors, it is ripe for abuse. They have limitless, unlimited power, total monopoly on power, total ability, unlimited financial resources, so they can just basically do whatever they want. And when you create a situation like that, where there's ample opportunity for you to do whatever you want, there's almost no oversight, you have unlimited power, unlimited resources, you're going to do what you want to do to further your ends. Man and women, we are only human. Ethical, moral guidelines will bend when you're put in a situation like that. And that's exactly what our system has done with the FISA courts. We have Leafy Bug in the house, says, who are the FISA court judges? I don't know them offhand. What's the process for their nomination and appointment? Well, you just heard it from Liberty. Judges are basically appointed by the Chief Justice, and there's no confirmation process. So they're there, right? I imagine lifetime tenure like the rest of them. So yeah, kind of a broken process and something that needs to be addressed. We'll see what Christopher Wray has to say about any of that. Great questions, though. All of those, of course, came over from watchingthewatchers.locals.com. Want to welcome some great new people who joined up. We've got Wokes Bane in the house. We have Shot Gal. We have Guess, and we have TMN5947. Want to welcome you four to the community. Very excited to have you here. If you want to sign up, go to this address down here. Type this into a web browser. watchingthewatchers.locals.com. Big happy shout out to all of you who participated and asked great questions today. Very much appreciate it. Also a big shout out to some of those of you who are a part of the community. Now locals.com, we're going to be cranking out some more content over there. My second studio is very close to being done. I've got some nice little finishing touches I got to put on it, but I'm going to start being able to, record a little bit more, produce some stuff on the weekends, after hours, maybe, host a book club, host some meetups. So I'm very excited about it. I got a lot of good ideas from the locals community creators call that took place yesterday. And so some pretty big ideas. And I'm very thankful to all of you who are helping to make this possible. I mean, literally, if you weren't there supporting us, we would not be able to start working on this. And, you know, when YouTube demonetized us and when we started to look like we may have been on the outs of YouTube, I got a little bit nervous. Like, you know, what are we going to do? Our firm relies on this. You know, we have a bunch of employees here who embody the message, right? We want to help good people who've been charged with crimes, and we want to reform the justice system, which is why I started this channel and started this show. And then YouTube kind of didn't like that. So that made me a little bit nervous, but it warms my heart that there are still people who will say, all right, listen, we are going to build something. We know that maybe conservatism or libertarianism or free speechism or anti-wokeism or whatever, you know, maybe we're going to be out in the wilderness for a little bit because we all got kind of caught flat-footed during this last exodus, during the last Trump cancellation from all the platforms, during the Parler cancellation. There's a cabal of people trying to control the narrative that takes place on the internet. That's a scary thing. But the right and the people who are mostly interested in free thinking, they are responding and they are creating new platforms and new decentralized solutions, and they are fortifying themselves against further threats. That's happening on locals and elsewhere. We're just putting our stake in the ground on locals. And the fact that you're helping us build that is such a cool thing. I think it's going to be a very nice home for us for the foreseeable future. And I'm very excited to get to know all of you better. And I'm just grateful that you're there. So thank you for supporting us at watchingthewatchers.locals.com. If you're not there yet, you can go and get a free copy of my book. It's called Beginning to Winning. You can download that there. Also, download a copy of the slides. You can get a copy of my impeachment party document. You can download a copy of my existence systems template. You can share links. You can meet all the great people over there, and we want to see you there. I am, lastly, before we get out of here, a criminal defense lawyer here at the R&R Law Group. So if you happen to know anybody in the state of Arizona who's been charged with a crime, we would love the opportunity to help. We offer free case evaluations. We can help anybody who is in a difficult situation find safety, clarity, and hope in their cases and in their lives. So whether it's a DUI, domestic violence, drug offense, felony, minor, major, anything in between, we can help. We would be honored and humbled if you trusted us enough to send your referrals our direction. We'll make sure that they leave our office better than they found us. And that, my friends, is it for me. We are going to be back here same time, same place tomorrow, 4 p.m. Arizona time, which is the Pacific time, 5 p.m. Mountain. We have 6 p.m. Central in Texas and 7 p.m. on the East Coast for that one Florida man. Everybody, thank you so much for being here. Have a very lovely evening. Sleep well. Have a nice dinner, because I'll see you right back here tomorrow. Bye-bye.